to talk about something I just found right here. It's called the whole rule, the whole act rule. Sorry about that. The whole act rule. And I'm going to start by reading this highlighted part. This is coming from California Globe website. I know, of course, I'm in Georgia, but I just found this to be kind of helpful because it speaks about the language that they use concerning when they're putting together statutes and codes, and so that there's a proper interpretation of what the terms are, the meanings of the terms that they use in the statutes and codes. Okay, I'm going to start out by reading right here. The whole act rule provides that a statutory provision should be interpreted so that they have whole, coherent meaning. In other words, identical words in the same or related statutes should have the same meaning ascribed to them. Okay? It's, in other words, identical words in the same or related statutes. Keep in mind, just like if you got the same title. Remember when I was telling you in the previous video, another video, maybe about last week I dropped, when I was talking about, say, if you looking at United States and it's all in that same title, they're going to have the same meaning in that same title. That's what they're talking about. In the same or related statutes should have the same meaning ascribed to them. And say you might go to a totally different title, you're going to find, you just may find a different definition for that same word. So this is pretty much to kind of keep confusion down. Because I think a lot of us, we have a lot of confusion in what we're doing when we're teaching that a particular word means one thing as if it can't have multiple meanings. And that brings a lot of confusion across the internet when we're regurgitating things that people are saying because they don't damn study. And they're regurgitating the same thing that they've heard instead of looking the stuff up. The basis for this rule is that the canon of construction assumes that the legislature drafts purposefully and is consistent with their word use. Okay. See, as a result, the whole act rule is a contextual canon that provides when construing a statute. When construing a statute, the text of the entire statute as a whole must be considered by the court. For the purpose of statutory construction, I'm going to start at the beginning because I didn't read it. The courts and bills drafters use a series of canons to guide them. These include textual canons, intrinsic aids, linguistic presumptions and grammatical conventions, substantive canons, and extrinsic aids. Say it is impossible to list them all, but there are some common canons, and those are most useful for legislative drafting. We start with the presumption that the legislature drafts its bills carefully and intentionally. Because of this presumption, the usual approach of the judicial branch is to narrow statutes rather than expand them. And the courts are less activist in their interpretation, and that's where the whole act rule comes in at. I'm gonna see what some of these other states may mention about the whole act rule. Let me see if I can go out of there. Whole act rule. Let's see, construction cans. It's not mentioning it right there. Legislative process. Let's see what that has to say. This Chicago. Let's see what it has to say about the whole act. Let's see, I don't want to get caught up on something. Okay, whole act rule. Now this is, let me see where this come from. This is Chicago Kent College of Law. Okay. It's a piece of, it's a PDF right here. See what it has to say. Maxims of words and meanings association. This summary is taken from page 1936 of the case book. I guess that's what this is about right here. Legislative process. It does not replace careful careful reading of the casebook, which discuss each of these canons in detail and provide exceptions to them. In addition, remember that these canons are guides or arguments, not absolute rules. They can be trumped by, for example, the court's understanding of the legislative intent, for example, or by other canons. Okay, it's probably how they come up with their little loopholes. Anyway, let's see. Make sure make this a little bigger. Okay. Maxims of word meanings and association. Meaning and association. The words are generally used. So words are generally used in their ordinary sense, but sometimes also in a technical sense or according to the accumulated meaning through court decisions. Meaning accumulated, more so like how it's understood throughout the, after it's being used so many times, people have a implied understanding that this is what it means because this is what it means most in previous times when it was used. So I suppose that's what they're saying when they say that. I'm not sure how to pronounce this damn word, so I'm not gonna play with them. Let you look at it, which means it is known from its associates. Okay, this is basically what I just described. This canon suggests that we can understand the meaning of an ambiguous word by looking at the other words it is grouped with. Oh yeah, well that ain't what I described, but that makes sense. Like basically when somebody uses a word in a sentence, you can figure out what it means. Let's see. What's a egistem, generis, which means of the same kind, class, or nature. This suggests that general words listed along with specific words should be given a narrow construction. The particular words indicate the class, and the general words extend the provisions of the statute to everything else in the class. In order for this to apply, all items listed must be similar enough to belong to the same class. Now, expresso or inclusio. Unius est exclusio, alterius, also means the inclusion of one thing indicates exclusion of another. This suggests that if the legislature has mentioned certain types of things, it meant to exclude other things. I've heard that before when I was first, studying before. And I think that's in a case-by-case basis. I think it's in a case-by-case basis. I'm going to show you an example of that in a minute, what I'm talking about. It's just like when they say, I saw just like before I started pushing record, I was looking at something where it was talking about the definitions area in, when it's talking about signature in the definitions area. It says it includes, no, not signature. It says oath. It said oath, and it was in quotation marks, and it says includes affirmations. So it does not mean swearings. You know what I'm saying? It doesn't mean that if you swear, you swear or affirm. I say swear or affirm. You could swear or affirm, and they're both are oaths. You know what I'm saying? So, anyway, I don't want to drag this thing on out. I can take off on different areas. Y'all got to stop me sometime. Grammar canons. Punctuation rules. The court can consider punctuations as an aid to interpretation. The last antecedent rule, referential and qualifying phrases refer only to the lat antecedent. Note that the punctuation rule can trump with this canon. I wonder if they have an example of that. The and versus or rule say the word and generally implies conjunctive, while the word or generally implies disjunctive. Okay, it means you have a choice there. It could be one or the other. Okay. The may versus shall rule. The word shall generally is mandatory and provides for no discretion. The word may often allows for discretion by the actor or decision maker. Okay, most of y'all know this already, but I think this video still is necessary. So it's basically when you're reading these statutes, you understand these are the principles, the maxims that they actually go by when you reading statutes. Terms, understanding what they mean, whether it's a term or whether it's a phrase, how they express it. You know, it's good to understand these grammar canons and the maxims of words. Okay. Let's see. Here's number 9 right here. Singular and plural, male and female pronouns. That's a big topic nowadays. In general, courts do not rely on whether the statute is written in a singular or plural, and whether it is used male or female, whether it uses male or female pronouns. Most of the time they don't. Now in the old, like if you look at something that was way back in, that was written back in the 1800s or the early 1900s, you'll see mainly him and his. You'll see that mainly in that, because generally, that's why, women didn't have the rights that they do today. They couldn't own land, couldn't vote, couldn't work. They're free to do whatever the same thing men can do now. So they would probably not even, they wouldn't specify him all the time. Sometimes they would, but they're not big on it like they were in the old documents that you go back and read, from the old stuff. Okay, there's another reason why I don't have a problem looking at some of the revised versions of certain things, because the times change. And so when the times change, they're going to have to revise certain things inside some of the statutes and codes. We can't be stuck on reading, thinking because it has a better definition, but it was written back in, 1845, it's best to just use that one, when here we are in 2023 and the times change, and the, society is changing, and it's constantly changing. And so you don't want to just abandon what's new because you want to stick with something that's old. It's like trying to, use an 8-track in 2023. Some things are just kind of obsolete. Some things is usable. Some of it's usable. Some of it's not. So it's good to kind of have a balance of going to the old and going to and kind of seeing where the new fits in, and kind of let your conscience be your guide. Okay, number 10, the golden rule. This is not so much a canon as an escape hatch. Court should avoid absurd results and should be willing to correct Scrivener's errors or Scrivener's errors. Okay, whatever the hell. Let me make sure I understand what that is. I like to look up these types of terms so I can understand what it means. This is how you research, y'all. You got to be willing to look stuff up. The hell does that word mean? Is a writer or professional drafter of instruments such as contracts, wills, or other documents. Whoever wrote it up. Okay, somebody might have made an error when they wrote up something. So whoever wrote it up. Okay, so a court should avoid absurd results and should be willing to correct, basically whoever wrote it up, correct their errors. Okay. Now, the whole act rule, that goes back to the whole act rule. In general, the whole act rule requires the court to read the statute as a whole, and it says there is a presumption of coherence. Okay, number 12. The title of a statute can be considered to resolve uncertainty. The title of a statute can be considered to resolve uncertainty or to help correct obvious errors. Number 13. The preamble can also be considered to discover the legislative intent. That makes sense because it has the purpose in there, just like you got the preamble that comes before the Bill of Rights. You see those different things right there, right before the Constitution actually starts. Okay, provisos which restrict or narrow the statute should be narrowly construed. Okay. Proviso. Let's make sure we understand what they mean by provisos. Provisios. Get your ass over here. Okay. The clause or legal instrument, a clause in a legal instrument which such as a contract, deed, or statute requiring that something must occur or not occur before another part of the agreement, or the entire instrument itself can be valid. Okay, all right. So you see, that's what it means. It's strict and narrow. Say which strict or narrow into the statute. Say it should be narrowly construed. Okay. Okay. Now, rule to avoid surplusage. Rule to avoid surplusage. Okay. In case you don't know what a surplusage is, I like to look these words up so you understand what you're reading. Surplusage is a language contained in a pleading that is unnecessary or irrelevant. Okay. I try to tell people not to use that type of stuff when they're venting in their paperwork, when you're typing up your documents, and don't put too much of your emotions and stuff, because then you find yourself venting about shit in your paperwork that you don't even need in there. It's not even relevant to the case. It's not relevant to the results you're trying to get. Like it's extra stuff. You're really just kind of venting on paper, but you need to stick to the meat and potatoes and that's necessary. That's actually required in your paperwork for it to be effective, so they won't get bored reading your stuff because you're venting. Straight to the point. Get off the paperwork. Okay, straight to the point and end it. So anyway, surplusage is a language contained in a pleading that is unnecessary or irrelevant. I never knew that was the legal term for it, but that's what I used to do this. Surplusage. I did a lot of that in my child support case. I was venting, upset, racing against time, desperate for a change, for some results. Yes, I was objecting, and everything I typed up, I was objecting, every damn thing. But I had extra stuff in there. I was explaining this, explaining that, quoting the Constitution, copying and pasting, case laws and all types of federal codes and everything in there. I'm just like copying and pasting stuff, basically trying to school them while I'm also venting at the same time. So my paperwork had a lot of surplusage in there. So be mindful about surplusage in your paperwork. Okay, just be straight to the point and get the results you need. For example, in an indictment, surplusage is an allegation of any fact or circumstance that is not a necessary element to the offense. Okay, it's an indictment. Surplusage is an allegation of any fact or circumstances that is not necessary element to the event. They talking about other stuff that ain't got nothing to do with the case. You know what I'm saying? So they basically same thing I was doing with my child support case. Okay, so I thought that's a good little nugget right there for you to keep in mind when you're putting your paperwork together. Okay, rule to avoid surplusage. There is a presumption that every word or phrase adds something to the command, and the statute should not be interpreted. They talking about when it comes to statutes here, but this rule still applies when you're putting your paperwork together, when you're in a pleading and you're actually typing up your paperwork, you working a case. Okay, so you also want to avoid surpluses just like they're avoiding when they're putting together statutes, and these statutes for people to understand what they're trying to relate to us. Say there's a presumption that every word or phrase adds something to the command, and the statute should not be interpreted. Let's see. Number 16, presumption of consistent usage and meaningful variation. A word is generally understood to have the same meaning throughout the statute. I said that before. And sometimes even throughout the code. As a Colora or Collary, let me see how to pronounce that properly. I might mess that word up just by, Collary. Let's see, a change in language generally denotes a change in the meaning. Yep. Let me go back and I want to see how damn you pronounce that properly, because I be messing words up sometime. Okay. Collary. Say collary. I suppose that says collary. Say a collary is a statement that follows naturally from another statement that has either been proven or is generally accepted as true. Okay, let me see. Pronounce. Make sure. I'm just kind of curious.
Corollary.
Collary.
Corollary.
Collary. Okay. I was right. Okay, back up. I was struggling for a second, but I got it. Collary. Okay. Collary. Anyway, it's a change in language generally denotes a change in the meaning. Okay, so a word is generally understood to have the same meaning throughout the statute, and sometimes even throughout the code. So if just like I said, when using title, whatever, I forgot what title that was when we were talking about the United States. United States has multiple meanings, but it has the same meaning when you're sitting there. You're in that same title, you're in the same statute, same code, same area where it's covering that particular talk about. When it talks about nationality, anytime when you look talking about nationality in the U.S. codes, I forgot which code that was. U.S. codes. That 8? Guess it was 8. Yep, it was 8. Title 8. Okay. In this code, the U.S. code, definitions are generally, it's going to be, let's see. Where the hell I get that from? Anyway, I don't want to get off topic, but as you know, let's see, where were we? Anyway, I want to stay with where we at, where we stick to. Here it is, nationality definitions. Okay, we ain't gonna play with that. But anyway, if you're in the same title, same code, if you're in the same area where it's covering a particular topic, those terms are gonna generally mean the same thing. It's not gonna change meanings throughout that code, because that's what's gonna bring confusion. If it means, you got one statute coming right behind the other and they're in the same code and they have two different meanings, you got to click on that link, that hyperlink every time in order for you to make sure that they're not changing it up on you. That will bring confusion if you got to do that. So they make sure that it has the same meaning every time they use that term in that particular area, because they're covering that particular topic. When you talk about, like, say, nationality, for instance, you talking about a global topic. That's dealing with global. When you're talking about someone getting a passport and they have to travel the world, you're dealing with other nations, other land masses. So of course it will most likely be talk about the geographical in a geographical sense when they say in the United States. So it just makes sense to do it like that, and that's exactly what they did. Okay, 17. Rule against interpreting a provision or derogation of other provisions. The statute should not be interpreted in ways that would create conflict between the provisions of the statutes, or in ways that would undermine aspects of the statute. Same thing I was talking about. Basically changing up the meaning on certain words and not making clear what they're saying and what they mean. So that's why in every area you always see a little spot where they actually have a definitions area. Depending on what topic they're talking about, they always have, every area has a definition. Every title, these statutes always have these definitions. So I thought I'd just kind of make this video to basically, it goes about the rule, the whole act rule. I became want to say whole rule act, but it's the whole act rule. Okay, that's what it's called, the whole act rule. And so I let you play with that the way of you, however you want to play with it. I just thought I'd kind of make a videos, kind of make you all kind of share that little bit that I found, and you can actually find this yourself if you want to Google it. Just Google the act rule, the whole act rule. And I'm gonna get on out of here, y'all, and I'll catch y'all on the next video. All right, M Rose signing out.